Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is here, everyone. Welcome back for more SPTV, where every day is a great day not to be in a cult. Danny Masterson's legal defense team done messed up, y'all. Done messed up. They are facing sanctions for tracking down the jurors in the second Danny Masterson trial and showing up uninvited to their homes to question them. Now, I have learned last night, after getting some information from ... because, by the way, even though it's against the rules for these lawyers for the defense team to track down and show up uninvited at jurors' doors to ask them questions, the jurors themselves are allowed to speak voluntarily with whoever they want to. And luckily, some of them have been willing to speak with me. And what I found out last night is what these investigators are trying to hunt down is evidence of juror misconduct, if you can believe that. So anyway, yesterday I was able to get my hands on, it was shared with me, a copy of the actual letter that was sent out to all of the jurors by Judge Charlene Almeida, the judge who presided over both Danny Masterson trials. And I wanted to share that information with you. And also, it turns out I'm going to do another video about this later today with my lawyer friend Zach to discuss the ramifications of what Danny's the investigators for Danny Masterson's defense team have done, because it's quite serious. Now, yesterday I was under the impression, because I think this is what was reported in the LA Times, that it was the prosecutors in the Danny Masterson case who was asking the judge to consider sanctions against Danny Masterson's legal team. But after seeing these letters, it's actually the judge herself who is warning the defense team that she is considering sanctions against them, which I think is even more interesting. One of my prosecutor friends, Carrie, I'm not using your full name because I don't think I have permission to do that, emailed me yesterday and said, I just watched your video on Danny Masterson's criminal defense team acting improperly towards jurors from the second trial. I just wanted to say that I was a prosecutor for about 8 years. I'm not going to say which state. I was on the major crimes units for multiple counties on death penalty cases, etc. I also clerked for a superior court judge for 2 years. The idea of showing up at a juror's home, especially given the protections of California's Rule 237, is shocking. In criminal law, a person is considered to be in an inherently coercive setting if they feel they cannot safely leave. It's incredible to me. It's incredible to me that if the defense team did want to actually have productive communication with the jurors, that they wouldn't establish communication in a non-threatening way, a non-threatening, non-intimidating way first, to check for consent to have further communication. If you're a juror and you're under the impression that your identity has been completely sealed and protected, and you have an investigator for Danny Masterson's team showing up at your door after you just helped put Danny Masterson away for 2 consecutive life sentences, would you not feel intimidated and threatened? I know I would. Okay, so let me just share this letter with you. I do believe that technically everything we're looking at here is in the public record, but this is a copy of this was mailed hard copy to all jurors and alternates. And let's just see. This is from the judge. This is from the judge herself. Let's just see what she had to say. To all trial and appellate counsel, it's come to my attention that since the verdict in the above captioned case was returned and recorded, members of the defense team have been contacting trial jurors and alternate jurors. Upon the return of the verdict on May 31st, 2023, I ordered that all juror identifying information be sealed. As of this date, I have not unsealed that information. Since the discharge of the jury, I've been contacted by several jurors who have informed me of unwanted contact at their homes or work by members, unwanted contact at their homes or work by members of the defense team, and to inquire how the defense team obtained their identifying information. After receiving the most recent juror complaint on September 17th, 2024, I'm reminding all counsel of their obligations pursuant to Code of Civil Procedure, Section 206. Code of Civil Procedure, Section 206C sets forth as follows. If a discussion of the jury deliberation or verdict with a member of the jury pursuant to subdivision B occurs at any time more than 24 hours after the verdict, prior to discussing the jury deliberation or verdict with a member of the jury pursuant to subdivision B, the defendant or his or her attorney or representative, or the prosecutor or his or her representative, shall inform the juror of the identity of the case, the party in that case which the person represents, the subject of the interview, the absolute right of the juror to discuss or not discuss the deliberations or verdict in the case with the person, and the juror's right to review and have a copy of any declaration filed with the court. Okay, so it does seem that Judge Almeida's concern in the interactions between investigators for Danny Masterson's team and the jurors is that in these cases, it does not seem that the investigator made a point to inform the jurors that they do not have an obligation to have this conversation with the investigator. All right, let's see. There's multiple pages to this. We're not going to go through every word of every page, but let's just keep going here for a moment. Code of Civil Procedure, Section 206D sets forth as follows. Any unreasonable contact with a juror by the defendant or his or her attorney representative or by the prosecutor or his or her representative without a juror's consent shall be immediately reported to the trial judge. Guys, is it unreasonable to show up unannounced and uninvited at someone's door when you're an investigator for the team of a person that you just helped send to prison for 2 consecutive life sentences? I guess reasonable and unreasonable are open to interpretation. They're somewhat subjective. I just feel that if you're an investigator and you are able to find out where a person lives, you're also able to find out their phone number and their email address. And I don't know. I'm just totally just speaking from my personal opinion here. I have no legal basis for the following in any way, shape, or form. I just feel like if you're going to show up unannounced and uninvited and knock on someone's private residence, you should at least have already established maybe an attempt to make a phone call, send an email, leave a voicemail. Because otherwise, I just find it threatening and intimidating. I find that to be threatening and intimidating behavior. I don't exactly know how the law would view it. And although my prosecutor friend Carrie gave her opinion, again, I'm also going to get my lawyer friend Zach's opinion on this. Okay, the judge goes on to say that any violation of this section shall be considered a violation of a lawful court order and shall be subject to reasonable monetary sanctions in accordance with Section 177.5 of the Code of Civil Procedure. She proceeds to give some excerpts from case law. I'll read this section. Although such unwanted contact may occur after the verdict and discharge of the jury, the trial court continues to have an obligation to jurors to protect them from such conduct. Upon being apprised of juror anxiety resulting from contacts by defense investigators, the trial court did not overstep its authority in directing that all further communication would be through the court clerk unless jurors were already agreeable. Okay, so that's the precedent for the order that Judge Almeida subsequently issued. Okay, she goes on to state, in the instant case, a review of the jurors' complaints received by this court indicate that some of the jurors may have felt pressured by the defense team, that the jurors were not first advised, that they had the absolute right to not discuss the case if they did not want to do so, and that the jurors did not want to be contacted by the defense team and were troubled that they were approached at their homes. If true, such contact by the defense team may be violative of Code of Civil Procedure, Section 206. As a result of these complaints, the court is issuing an order that all further contact with trial jurors and alternate jurors must take place through the court clerk. See the attached order. Okay, let me double check what the next page is. Oh, here it is. Here's where the Judge Almeida herself is the one saying, I'm considering sanctions, y'all. All right, let's take a look. Furthermore, if necessary, and after conducting a full hearing pursuant to Code of Civil Procedure, Section 206, the court may consider the imposition of sanctions, if appropriate, for any unwanted and harassing conduct that is not in compliance with case law and the relevant statutory scheme. A copy of this letter is being sent to all trial jurors and alternate jurors. There you go. Let me see. Okay, now this letter So what was sent out hard copy to all of the jurors included the attached emails. And since it's in the public record, and since this is what was sent, let's just take a look at this. And these I've put these in chronological order now. Okay, so this is wow, this is over a year ago. Guys, here's what's really interesting to me. Danny Masterson's team has had over a year now to file his appeal. They have not done so. They have not done so. They've requested multiple extensions, been granted multiple extensions. One of the things that I find interesting is that the investigators are only within about the last 8, 10, 12 weeks, only now are going out and talking to these jurors. They've had all this time. Why only now? I don't know. Okay, so this is July 5th, 2023, August, September, October, November. I'm not good at math, you guys, but that's about 16 months ago. Okay, hi, Robert. Robert's the clerk of the court, by the way. Hi, Robert, or Judge Almeida's clerk. This is blank. I was the jury foreperson on the Danny Masterson trial that just concluded. Defense attorney Sean Hawley contacted me last week at my workplace and left a message to inquire about asking a few questions of me. Okay, this brings something to mind. Sean Hawley was Danny Masterson's defense attorney. She's no longer, she's not involved in the appeal. Sean Hawley did actually make initial contact through the telephone. She wasn't just showing up at people's doors. It is the new attorneys investigators that are showing up at people's doors. So I just wanted to make that clear. Defense attorney Sean Hawley contacted me last week at my workplace and left a message to inquire about asking a few questions of me. I remember that the judge indicated that we couldn't do any interviews for 90 days. Is talking to her considered an interview? I was wondering, how did she know my name and workplace information in order to get in contact with me? I want to make sure that I'm acting accordingly. I'll await your response. Again, some speculation on my part here. The fact that the jury foreman is having to ask the clerk of the court, how did Sean Hawley get my information? To me, tends to indicate that perhaps she was a little too intimidated to actually ask Sean Hawley that question herself. Just speculating, because it does seem that that's a question for Sean Hawley, not for the clerk of the court. Okay, let's see. Next letter comes much more recently, about 4 months ago, 3.5 months ago. Good morning, Robert. I hope you're doing well. Some of the jurors have been visited at their homes by Danny Masterson's appeal team. We thought our information was going to be sealed. We don't recall the time frame of this. We are concerned. We would like to know how this can be handled. I am simply under the impression that email seems to me to also have come from the jury foreperson, even though she did not identify herself that way in the email. It does seem that way. So even an entire year later, she is still unsure how any of these defense team members or investigators are finding out the identities and the contact information of the jurors, which is interesting to me. Okay, I think this is the last email that was shared in the attachment, and this was literally just about 5 weeks ago. Let's take a look at this one. And this email, instead of going to the clerk, is going directly to the judge and is not from the jury foreperson. Good morning, Judge Almeida. My name is blank. I was alternate juror number 8 on the second Danny Masterson trial. At 2 p.m. Sunday, September 15th, I was contacted at my home by a representative of Danny Masterson's legal team. I was doing yard work in my front yard when a car pulled up, parked. A woman got out and approached me. She asked me if I was blank. I said yes. She said she was a member of Mr. Masterson's habeas team and wanted to ask me some questions about incidents regarding parking and in the hallway in front of the courtroom that resulted in the jury being sequestered. I declined to speak with her and asked her how she got my name. Now, interesting, in the representation of this conversation, at no point did the investigator say, you have no obligation to speak to me about this case. I really do think we are going to see sanctions here. I'm hoping we're going to see sanctions here. So I declined to speak with her and asked her how she got my name. She said she got it from another juror and said, so you declined to participate? So guys, does that not sound slightly threatening? It doesn't sound like a friendly invitation to politely discuss something you don't have an obligation to discuss. It sounds almost like, so what you're saying is you're not going to participate? I can almost hear it in my head. I told her I was declining and that I would be letting the judge know of this because juror information is confidential and there should be no contact with me by Mr. Masterson's legal team. She held up a hand and started backing away and said, okay, thank you, and returned to her car and drove away. Do you see? It continues to sound like a not very friendly interaction. The investigator was not trying to put the juror at ease, which is what you would expect the investigator to be doing unless they were trying to give the impression that there was some sort of an obligation to have this conversation, and there might be some consequences and repercussions if you don't cooperate. So I wanted to bring to your attention that a juror has given Mr. Masterson's legal team my name and cell phone number without my permission. And as a result, I was contacted in person by a member of Mr. Masterson's legal team at my home on a Sunday afternoon. Not the Lord's Day, y'all. Not the Lord's Day. Okay, and then this is the order from the judge saying, upon receipt of complaints from trial jurors of unwanted post-verdict contact by the defense team, the court orders any further contact by the defense team with trial jurors and alternate jurors to take place through the court clerk. See the court's September 17th letter to all trial and appellate counsel attached here too. Okay, now you'll notice none of these filings and whatevers and orders and affidavits included any information about seeking information about jury misconduct. That is additional information that's been privately shared with me, which I find very, very interesting. And I don't know, guys. Again, I'm just a layperson. My opinion on this is not professionally informed, but to me, that reeks of desperation. The fact that Danny Masterson's appeal team has been dragging their feet for the last year and at this late stage in the game are showing up unannounced to jurors' doors. And by the way, they're pulling one of these things. You see this in TV shows and movies all the time where you basically tell one person that another person has already spilled the beans on this, so you might as well just share the information with me. That's sort of the tactic that these investigators are taking with the jurors, is that, yeah, we've already had reports of juror misconduct. Is there anything you'd like to tell us? They really are approaching them this way. It reeks of desperation. I think the chance of Danny Masterson's appeal, Danny Masterson getting another jury is pretty much close to zero. But yeah, I know there's something slipping my mind. There was another point that I wanted to make here, but that's okay. I'll probably remember it by the time I do a video later with my lawyer friend, Zach. All right, just wanted to keep this as short as possible. Let's see, we got Matt Elliott, MAA, SPTV Canada. Are they asking about you and what happened in the hallway? So I actually, one of the jurors that I was speaking with about this, when I was told that, this is the thing that slipped my mind. There are multiple videos of this investigator, not Sean Hawley, but the investigator for the new attorneys. Multiple videos of how this investigator has approached the jurors, thanks to the ubiquitous Ring doorbell video cameras that are everywhere. I know everyone that comes to my house and knocks on the door ends up on camera for at least several minutes. So the judge is not going to have, should not have any difficulty in determining whether whether it's just a violation of civil law or criminal law, whether there's been a violation of the law in how these investigators have approached the jurors. But when I was told that what the investigator was asking about was juror misconduct, I actually said, oh, wow, I was under the impression they were trying to get jurors to say that they were somehow improperly influenced by the short argument that occurred out in the hallway between me and that fake reverend that was working for Scientology. And the juror said, oh, that was you? The juror had no idea. There was I want to call it an argument, but it wasn't an argument. It was just a conversation that resulted in a surprise, meaning we weren't arguing about anything. There was this fake reverend. I say fake reverend because he was there as a, I'm sure he's probably actually like legally a reverend, but he wasn't there in his official capacity. He was there as a, what do you call it? Sort of like a stooge for Scientology. This guy walked into the Danny Masterson, into the courtroom in the middle of the Danny Masterson court proceeding in like full Catholic priest garb. And everyone was like, what is going on here? There's some shenanigans afoot. And at the same time, this reporter, only people with media credentials are allowed to sit in the back row of the courtroom. And I had media credentials for that trial for SPTV. And this woman who'd never shown up before was randomly there. Nobody knew who she was. And she was in the media row. And she was sitting right next to me. So I was aware that she could be looking at my notes. But so that this is like, these two things happened on the same day. New woman shows up in the media section. Random guy shows up dressed in full Catholic garb. And needless to say, all eyes were on this guy. And I think Leah Remini was in court that day, and she even tried to give him the what for, like, who are you? What are you here for? You're here with Scientology, aren't you? It was generally assumed that this guy was somehow some secret Scientologist showing up to put on some performance. So anyhow, since I was in the media section, as court was getting out for lunch, they always dismiss all of the jurors first to try to minimize interaction between jurors and anyone else. And just so also they have all the time they need to properly eat and everything. Once the jurors are out of the courtroom, then they let everyone else stand up and they start dismissing everyone row by row. So as me and the priest guy were walking out, I was just chatting with him, like, "Hey, are you here to observe?" Or and he started to tell me he was here out of some sort of a protest for the fact that the judge had made a ruling allowing a certain amount of testimony on the subject of Scientology policies and procedures to the extent that they applied to the victim's states of mind and other relevant issues in the case. And at this point, I was just taking him at face value, at his word. I wasn't necessarily under the impression he was there for Scientology. And he seemed perfectly willing to talk to me, which is a surprise because normally someone working for Scientology would not be perfectly willing to talk with me. So we were standing there in the middle of the hallway while people were still walking past us. And I said, you know, I'm not sure I understand. Like the point that you're bringing up is something that's already happened in the case a while back. And it's not like you're here to protest. It's not like you're here to ask the judge to reconsider. What actually is the point? He said Scientology had asked him to come and sit in on the proceedings. And I was just really trying to get to a point in this conversation where I understood. I was like, why would Scientology? I said, Scientology's already got a bunch of people here listening to the proceedings. Why would they need you to come and listen to the proceedings? This wasn't an argument at all. It was just a conversation. And again, I was surprised that he continued to be perfectly willing to talk to me. And I figured, I don't know, maybe he doesn't realize he's just kind of being used in some way by Scientology and he hasn't figured it out yet. And I haven't even figured it out yet, but it sure seems like that's what's going on. And it was a friendly conversation. And then all of a sudden, the new reporter woman walks right up to us and just stands right there. And I didn't take a close look at her tag at first. And I was like, oh, okay. So you're a journalist. You know, he's sort of like your, like he goes to things and then you write about it. And she goes, I'm with the Stand League. Now, Stand League is a fake little front organization that Scientology created to be Scientology's version of the Anti-Defamation League. I say it's a fake organization because it's just run by Sea Org members and Scientologists. It's not a real organization. It's just something they're doing to try to look like there's some grassroots support for calling out Scientology hatred and bigotry. In reality, there's no such thing as Scientology hatred and bigotry. There's really just telling the truth about Scientology's destructive policies and practices. And so anyway, once she walked up, she's like, I'm with Stand League. I was like, you guys are here together? And she's with Stand League. You're literally here with one of the propaganda pieces for the effing cult. You got to be kidding me. So anyway, I was expressing my disbelief, but this wasn't an argument. We weren't like yelling at each other. And I wasn't even yelling at him. I was just speaking loudly. But because I swore, I said the effing cult. And then at this point, Leah Remini walked up and started, being like, you should be ashamed of yourself. I forget exactly what she said, but you basically had me and Leah and the Reverend and the OSA volunteer. And so it looked, now there's 4 people standing in the middle of the hallway, and all of a sudden voices were elevated. So it and a curse word was used. So it sounded like actually an argument when it really wasn't an argument. And then the bailiff came over and said, hey, you guys can't, pipe down. It's like, I'm sorry. Okay. So then what had happened was, it turned out, even though all the jurors had been dismissed prior to us, and even though we'd already been standing there, kind of slowly walking and chatting in the hallway for a few minutes, there were still a few jurors that had not yet gone down in the elevator. And so they had heard some raised voices, about 20, 30 feet away in the hallway, because the elevator lobby is a little halfway down the hallway and, dog-legged over. So what they heard was some raised voices, an F word, the word cult. And so, of course, the defense attorneys, I don't know if you guys were, some of you out there who watched all the proceedings of the first Danny Masterson trial and the second Danny Masterson trial will know that in the first trial, they asked for a mistrial, almost no exaggeration, not only every single day, but sometimes multiple times a day. Their main strategy was just to try to ask for a mistrial all the time. They didn't do that as much in the second trial, but because Scientology was so much more of a subject of testimony in the second trial than the first trial, the defense team was also much more sensitive to the idea that the jurors, this is what the defense team argued, the jurors had already been brainwashed into thinking that Scientology was behind so much of the shenanigans in this case, that they were like, oh my God, now the jurors are going to think that Scientology sent someone to the proceedings to cause upset and intimidate people. But really, it was Asmithlevin who was raising his voice in the hallway. But the jurors are going to think it was a Scientology agent. And the jurors have been completely, hopelessly prejudiced. And we must have a mistrial. And so after lunch, the defense team made their whole presentation for how, oh my God, the jurors are going to think Scientology sent people here to threaten people. We must have a mistrial. And the judge brought all the jurors back out and was like, did anyone hear any commotion in the hallway? And I think 3 or 4 people said yes. And then she asked them one by one, okay, what did you hear and who do you think said it? Every single one of them had a different recollection or perception of what it is that they had heard. Nobody had any concept of who had said what, and the judge just quickly put it to rest and dismissed the whole thing. But what did happen after that is the jury was from that point on sequestered. Not sequestered like put up in a hotel and everything like that, but they were given lunch every day and allowed to eat in private quarters. They didn't have to go downstairs and eat lunch with everyone else and to interact with anybody. They were given escorts into and out of the building. And it turns out that is what the Jane Does in the case had requested in the beginning and wanted all along and had been denied. So even though I certainly don't deserve any credit for getting them sequestered, because it certainly wasn't on purpose, I can tell you that the Jane Does very much thanked me for that. And anyway, it's not fair. I don't deserve any credit for that, but it was sort of a happy little accident that, the jury did get sort of, I guess it's a soft sequestration. Yeah. So that's what happened on that. I thought for sure, well, actually just based on one of those emails, I thought for sure that the investigators had been trying to get the jurors to admit that they really had been negatively influenced by hearing these interactions in the hallway and had just been like afraid to admit it or something like that. But no, they're actually looking for jury misconduct, which is really the breaking news of this video. Thank you for the question, Matt Elliott. Crystal Moon, member for 8 months. Thank you for being a channel member for 8 months. This just shows who and what this insidious organization is. Absolutely. And Daniel Sander, thank you so much for gifting 5 channel memberships. I appreciate it. All right, guys, stay tuned. So much more to come later and the rest of this week. Hit that like button, hit that subscribe button, even if you're here and you're not yet subscribed. I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe